1059 The Region, in partnership with Remax Prime Properties, present On the Market, real estate advice that works for you. Have a real estate question? Call us at 416-335-1059. Tweet us at 1059 The Region or email us at info@1059theregion.com.
You're listening to 1059 The Region, and welcome to On the Market. This is York Region's exclusive radio real estate show. I'm station manager Tina Cortez, and my co-host and real estate expert is Asif Khan with Remax Prime Properties. Good morning, Asif.
Good morning, everyone. Let's start off this week by checking in with our regular guest expert, real estate broker and lawyer, Ricky Rathore. Ricky, welcome back.
Thank you guys again for having me.
Ricky, there's a lot of chat, and I know you and I were talking offline about a question one of our potential buyers had was she was on title for an investment property that her parents purchased back when she was 18 years old, and now she's wondering how that, she never took, it wasn't her property, it was just an investment property. How does that affect her now that she's getting married and purchasing a home with her fiancé? How does that affect her first-time home buyer status?
That's a bit of an unfortunate situation. So this is actually, it's interesting, Asif, because first off, you don't qualify for the first-time home buyer rebate on an investment. And more importantly, there's very specific criteria. So here's the criteria for everybody listening. You have to be at least 18 years old. You have to occupy the property as a principal residence within 9 months of the closing. The property has to be residential, can't be commercial, industrial, or anything like that. It has to be residential because you have to own or occupy it. You have to be a Canadian citizen or permanent resident, and you cannot have owned an eligible property anywhere in the world. Now, going to the scenario at hand here, because she took title with her parents, first off, that property, they wouldn't have been able to qualify, because some people, what they'll try to do is they'll try to qualify for the rebate on that property. So her parents may have attempted, as an example, to set it up where she was a 99% owner, the parents were 1% owners, thereby entitling her to 99% of the first-time homebuyer rebate. But the lawyer acting on that file probably would have shut that down because she wouldn't be able to certify through an affidavit that the property was going to be owner-occupied by her as a principal residence. There's a couple of qualifiers. Now, the other thing to keep in mind, too, is that when you're marrying somebody, if they own property and that property is coming into the marriage, if you're a first-time home buyer and your spouse owns real estate and you marry that individual, you lose your rebate. Whereas if your spouse, before you get married, sells off all of their assets, then you both qualify for the total rebate on that acquisition. But it's one credit of up to $4,000 in the province of Ontario. If you're buying in Toronto, Ontario specifically, you get another $4,475 today.
So that's part of the Toronto land transfer tax as well as the municipal or the Ontario land transfer tax.
That's right. So anywhere in the province of Ontario, you pay the province. Mm-hmm. In Toronto specifically, you pay the exact same tax amount. So you're basically paying double the tax, one to the province and one to the municipality of Toronto.
So if one spouse has previously owned a property and the other one hasn't, are they eligible for 50% of that back, or how does that work?
No. So spouses are very different. Mm-hmm. Let's look at the scenario where you've got a father and a son, right? So sometimes a client will call me and say, look, my dad has to co-sign my mortgage and come on title because that's how the banks want it structured. And in this situation, I'm a first-time home buyer, my dad isn't. What can we do? Well, in a situation like that, what we can do is either we can set it up so that the interest in the property are 99% in favor of the son and then 1% in favor of the father, or you can set it up as 50-50. But based on the share that we set up, you would be able to qualify for up to that amount. So if it's a 99-1, the son would qualify for 99% of the $4,000 in Ontario and then 99% of the maximum $4,475 in Toronto. So you can structure it that way. But for the parents out there listening, it's interesting because if you're not on point with your children and there's not a very good understanding in place, then if your child stops paying the mortgage payment, even though you own the 1% interest in the property, you are on the hook for that mortgage jointly and severally. So you can't just do this with anybody. You have to be very careful with how you structure these types of transactions.
So, Ricky, let's give some advice to those parents out there listening who are not thinking 10, 15, 20 years down the road. They're thinking about right now, I want to buy an investment property for my child. What do you advise them then to do?
So it all comes down to structuring, right? So the child's ability to qualify for financing is usually the most important thing, because most people don't have money just sitting in a park bank account, right? So the parents that are looking to make these sorts of investments for their children usually try to take the transaction on their own name, and then when the time is right, the mortgage is paid off or circumstances change where the child can qualify, then we can do interfamily gift transfers. And the transfer taxes on those are usually nominal because we can transfer them. It just comes down to how the deal is structured, so that you can plan it in the long run that way. For the parents that, can qualify their kids for financing up front, they may have to guarantee the loan. If they guarantee the loan, they're technically not on the deed at all. They're just guaranteeing, meaning that they're on the hook if the child stops paying the mortgage. The other option that most lenders prefer, based on our experience, is they want the parent to actually take title with the child. They don't care what the shares are, as long as the deeded owner is the same owner in the charge, and they will lend based on that. So you can structure it. It just depends on the financial capacity of the family unit, the child as an individual, and what the long-term goals are here. Because down the road, there's going to be capital gains. There's going to be other issues to deal with if it hasn't been structured carefully.
And that's important to note, is your long-term goals. You have to communicate that with your lawyer so that they can properly structure this, so that there's nothing that's going to come out of this 10 years down the line or 20 years down the line that's going to jeopardize that child's position or that buyer's position. So it's very important for them to communicate this with you at the beginning of the transaction.
Yeah, it's too bad that most people don't engage the attorney until the deal is done. But if you engage the attorney at an earlier stage, like we can set up trusts, there's ways of dealing with these sorts of things to really realize the actual requirement by the parties involved in the transaction. If we know upfront what they're looking for, what their long-term goals and intentions are, then we can try to help in structuring the deal so that those goals can be realized in the long run. But we have to be a part of that in the beginning so that we can structure it accordingly.
Now, Ricky, in the case of a cosigner or a guarantor, do they have to come to you first before they get approved from the bank? Is it too late once they've been approved for financing from the bank? Because the bank may have already said, this is a conditional approval based on both of you being 50-50 owners. What if you want to change that to a 99%, 1% ownership later? Is it a different qualification? What happens in that case?
So ultimately, when it comes to how we take title, we're usually able to do what we want unless the bank specifically says you have to be 50-50 shareholders as tenants in common, right? So if there's clear instructions, the bank have structured the deal that way, then we have to comply with the lender's requirements. If there's no condition or nothing mentioned in the commitment to that effect, then we can get a little bit creative with it, because as long as the bank sees a charge and a deed with both parties' names on it, they usually don't care. It only comes down when they actually put certain conditions, and that's rare. That's very rare to see where a bank comes in and says it has to be 50-50 ownership. Their main thing is you sign the mortgage commitment, you understand you're on the hook jointly and severally. The kid doesn't pay or the father doesn't pay. It goes both ways. You're both on the hook for that mortgage.
Great information, Ricky, and even more important for people not to count the rebate before they actually get it, because it really does depend on how the lawyer structures it. So thank you for that information. And if our listeners want to connect with you and ask questions about this, how do they get a hold of you?
You call me direct anytime, 416-731-8478. Again, 416-731-8478. And my last tidbit of advice here is that just be careful with what you're certifying and what you're putting out there, because if it turns out that you've made material misrepresentations, you'll have to return the money. There's penalty and interest and charges. So just, consult a professional, talk to your realtor, talk to the lawyer, and make sure that the deal is really crafted so that your long-term goals can be realized.
Thank you again, Ricky, and we look forward to having you on next month.
My pleasure. We'll talk to you guys then.
When we come back, expert opinion from the Sunshine State. Stay with us. You're listening to On the Market on 105.9.